There is one more day to the weekend, guys, so grab your tiny umbrellas. We are almost there. Good morning, everybody. I'm Brian, and this is the Aloha Friday Morning Report on the federal courts for September 19th, 2025. Please double tap your screen, like, comment your thoughts on adult coffee on a Friday. Recipe recommendations are welcome, and try to watch at least through the intro so that we float into the FYP. Click the link in my bio to help me keep this sustainable, please. And let's get to the news. Okay, we are going to start today with a recap of a story from about 2 weeks ago, where over Labor Day weekend, a bunch of unaccompanied minors were being sent home to Guatemala when the court intervened. And the DOJ took all the kids off the plane and returned them to ORR, which is the immigration version of child services, basically. And I tried to be very clear at the time that we did not have any facts yet, so it was a little premature to accuse anybody of anything. In fact, the federal government said that all these kids had been requested by their parents, and they were just reuniting them with family, and everything was totally cool. But the judge stopped it anyway because we like to confirm these things, right? So let's check back in. Well, a new opinion was just released by the Trump-appointed judge in this case. I'm just going to read you the first paragraph word for word. Just before midnight on the Saturday of Labor Day weekend, several executive branch agencies began to implement a plan to expel from the United States several unaccompanied alien children in the custody of the Department of Health and Human Services and send them back to their home country of Guatemala. Those agencies told the children's caretakers, who were hearing about the plan for the first time, to have them ready for pickup in as little as 2 hours. The children were roused from their beds in the middle of the night and driven to an airport where some were loaded into planes. And then one more quick quote from the second paragraph. At a hearing later that day, counsel for defendants, the government, explained why it was fairly outrageous for plaintiffs to have sued. All defendants wanted to do was reunify children with plaintiffs or with parents who had requested their return. But that explanation crumbled like a house of cards about a week later. There was no evidence before the court that the parents of these children sought their return. To the contrary, the Guatemalan Attorney General reports that officials could not even track down parents for most of the children whom the defendants found eligible for their reunification plan. And none of those that were located had asked for their children to come back to Guatemala. So, the plaintiffs here, representing the kids, have requested a preliminary injunction to prevent the unaccompanied minors from being removed from the U.S. throughout the rest of this case, and the court has granted that request. The court did limit the members of the class in this class action. The plaintiffs asked that the class include all accompanied minors from any countries that don't touch a U.S. border in the custody of ORR, and a couple of other stipulations, but I'm not going to get into those. But the court limited this class to unaccompanied minors from Guatemala in the custody of ORR and those other stipulations. And with the Supreme Court getting really touchy about the reach of equitable remedies like preliminary injunctions these days, it was probably a pretty smart move. By limiting the class a little, the judge made it less likely that the court would overturn it. I put a copy of this memorandum opinion in my shared documents if you want to take a look. It's in immigration cases under L.G.M.L. Remember, this is a Trump-appointed judge just kind of tearing into the administration, so it may be worth a read. Okay, we're going to check back in with our friends at TPS Alliance v. Noem again. We talked on Monday about Doe v. Noem, which was a case about parole status in immigration. TPS v. Noem is about temporary protected status, TPS. Parole and TPS are both programs that let the government bring non-citizens into the U.S., or let them remain here even though they don't necessarily have a legal reason to be here for a relatively short period of time. That's the short answer. So TPS is specifically for people who have some sort of a disaster going on back home, and we don't think we should send them right now. Could be a war, could be a volcano, could be a giant rubber ducky attack. Keep an eye on those guys, they're starting to organize. Parole is way more flexible. The government can use it for a lot of different reasons. Not all of them are even about the person they're bringing in. In the case we talked about on Monday, it was just about speeding up the lines at customs. But with that flexibility, with that lack of rules to grant parole, the court in Doe v. Noem said the government also has the flexibility to take it back. TPS is different because it's written in a way that's way more structured, and the purpose of it is to protect a group of people for a period of time. And so a couple of weeks back, the district court in this case, in TPS Alliance, said that unlike parole, TPS could not be taken back. Congress intentionally wrote it so that the people who get it know they are secure for whatever period of time is granted, which is usually 6 to 18 months, which is not that long. But the district court said that it can't be taken back. If it could, they would never get the security that the law was written to give them. Well, yesterday, the Ninth Circuit Court of Appeals agreed. The court held that Secretary Noem couldn't just vacate a TPS extension, couldn't shorten that 18 months that these grantees had been promised, and the court emphasized again that Congress locked that stability and security into the statute and did not authorize it to be revoked on a political whim. What's interesting now is that both questions, revocation of TPS and parole, have appellate-level opinions behind them. So we have a clean side-by-side example of two tools built with different purposes, different congressional intents, and different appellate outcomes. If both decisions are appealed, the Supreme Court could use this as an opportunity to review both of them and issue a single opinion that explains the difference between the two. The courts sometimes like to pair related cases to contrast them and draw a nice, clear line in the sand. This could be used as a contrast to lay out two different laws, two different sets of rules for how they're used. So keep an eye on this one. Okay, next, we had a hearing in District of Columbia v. Trump yesterday. This is a case about use of the National Guard in D.C., and this was just a hearing about discovery, or what evidence the government would be required to turn over to the plaintiffs. And the feds argued that there should be no discovery. No evidence turned over at all, because there was no evidence needed to decide this case. It was an open and shut on the law and should be just dismissed. And the judge should be able to figure that out without any further evidence. And since the court hasn't issued a written ruling yet, I can only speculate from what I see as to what the court is thinking. But DC did, in response to whatever the judge ordered in court yesterday, send out a revised discovery request yesterday afternoon, so we can make some pretty good guesses about how the judge ruled based on that. First, the court does not seem to have agreed that there's no discovery or that it was an open and shut case and it should just be dismissed, because DC did have to revise some of its discovery requests, but they're still there and they're still pretty broad. But, for example, the government objected to DC's original request asking for any communications where the feds requested DC's permission to send in the National Guard. They were probably just trying to get the government to say on the record that they hadn't asked for permission, but they were denied, and that is gone now. And the reality is DC should probably already have that stuff anyway. But most of the requests seem to still be there. Like, DC originally asked for anything where the feds requested support from state governors, and now they're asking for all communications with state governors about DC. So the judge may have even given them wider latitude in some of these cases. Point is, the case is moving forward. The judge seems to be acting fairly. I'm sure nobody walked away from yesterday totally happy, which is usually a good sign. And the hearing on the preliminary injunction is set for October 24th in courtroom 3 at 2 p.m. and it's open to the public if anybody would like to check it out. Okay, bartender, last round. Let's check in with American Oversight v. Hegseth. This is a case about the use of signal chat to plan a national security operation. We talked about it last Aloha Friday. But the problem wasn't that signal chat wasn't secure enough, but because the signal chat doesn't preserve communications as required by the Federal Records Act. We've got to have a record, everybody, for later, right? And the court required that the National Archivist step in and somehow be involved in this. But the government defendants here assured the court and the plaintiffs that they could prove every communication was recorded and memorialized and was now on the record. And though the court hasn't ruled on this yet, the plaintiffs are at least listening. And so the two parties just filed a joint request to stay or pause the next set of hearings so that they could try to work this out on their own. Now, the court is involved now, and therefore it may not be totally up to the parties to decide whether they're happy with this or not. But if the judge and archivist and the plaintiffs are all satisfied on at least this one issue, we may be on our way to closing another case. And in this one, a pretty painless one. So that's pretty good news, right? All right, everybody. That is your Aloha Friday Morning Report and a wrap on another week in the federal courts. Thank you all for your support. Again, I cannot do this without your help. Check my wish list because I'm running low on a few things. Fa'awatai lava, I really appreciate it. Mahalo for watching. Manuia leaso. Have a great weekend, and I will see you all on Monday.